You know, I've been doing this a long time. I serve as governor. I serve as president. And if there's one thing I've learned in all those years, it's that the strength of this country doesn't come from any one person in the Oval Office. It comes from the rules we all agree to follow. The institutions, the processes, the understanding that nobody, not a president, not an attorney general, nobody gets to just make up the rules as they go along. And what happened this past Friday, August the 21st, in the Second Circuit Court of Appeals? Well, it ought to matter to every single American whether you voted red, blue, or didn't vote at all, because what the court said in plain English is that the Department of Justice tried to put a prosecutor in place through the back door, and the judiciary caught it. Now, I want to walk you through exactly how this happened because the details here are important. And some of what I'm going to tell you, I don't think most people have heard yet. So, stay with me. Let me set the stage. Early in the second Trump term, vacancies opened up in U.S. attorney offices across the country. That's normal during a transition. Every administration gets to put its own people in those positions. But here's the thing, there's a process for that. The president nominates somebody, the Senate confirms them, and they take office. That's how it's worked since the founding. Now, there's also a law called the Federal Vacancies Reform Act, the FVR, that lets the Attorney General appoint somebody on an interim basis for 120 days while the Senate does its work. That's the temporary fix. It's meant to keep the lights on, not to create a permanent workaround. In March of 2025, Attorney General Bondi appointed a man named John Sarcone III as interim U.S. Attorney for the Northern District of New York based in Albany. Now, Sarcone wasn't a career prosecutor. He was a former campaign attorney for Donald Trump. He had no prior prosecutorial experience, but he was given the job on an interim basis, and the clock started ticking 120 days. That clock ran out on July the 14th, 2025, and when it did, the panel of federal judges in that district, the people the law says can extend the appointment, they declined to keep him. They said no. And in a functioning system, that would be the end of it. You go back, you nominate somebody, you send them to the Senate. But that's not what happened. Instead, Attorney General Bondi designated Sarcone as a special attorney and then appointed him First Assistant U.S. Attorney, a title he hadn't held before the vacancy ever opened. And then using that new title, the Justice Department elevated him right back to acting U.S. Attorney under a different provision of the FRA, one that's supposed to apply to a first assistant who was already in the job when the vacancy arose. Now, you don't need a law degree to see the problem here. They created the title after the vacancy specifically to get around the time limit. It's like showing up late for a flight, walking around to the back of the plane, and climbing in through the baggage hold. You might end up in a seat, but you didn't board legally. And then in August of 2025, Sarcone used that position to subpoena New York Attorney General Letitia James, the same Attorney General who had successfully sued Donald Trump and his family business in civil court, and who had brought a case against the National Rifle Association. 2 grand jury subpoenas aimed directly at her office tied to those very cases. And this is where things start to get really uncomfortable because now you've got a former campaign attorney for the president installed through a procedural workaround, using the power of a federal prosecutor's office to investigate one of the president's most prominent political opponents. That should give everybody pause. Now look, I want to be fair here. Supporters of this arrangement will tell you the Attorney General has broad authority to manage the Department of Justice, and the FB gives the executive branch flexibility to keep offices running. And that's a reasonable argument in the abstract. Nobody wants a U.S. Attorney's office sitting empty with no one in charge. I understand that when I was president, we had vacancies too, and I know firsthand how important it is to keep the machinery of government moving. But flexibility is not the same thing as evasion. There is a difference between using temporary authority to bridge a gap and using it to install someone the Senate never confirmed into a position of enormous prosecutorial power indefinitely. And the courts have now said so 3 times over. On August the 21st, the Second Circuit ruled 2-1 that Sarcone was not lawfully serving as acting U.S. Attorney when he obtained those subpoenas. Judge Guido Calabresi wrote for the majority that the FVR permits only a first assistant who was already in place when the vacancy arose to step into the acting role automatically. Because Sarcone became first assistant months after the position became vacant, the court said he didn't qualify. And here's what the majority wrote that really struck me. They said the government's reading of the law rewards evasion and penalizes compliance. And they called that a strange design for a statute Congress enacted to stop the executive from skirting the Vacancies Act. That's the court saying you tried to use the law against its own purpose, and that matters. And I want to pause here for a moment and talk directly to the people watching this. I care about you being informed on this. I really do, because the details in a story like this are everything. And most of what you're hearing on cable is the headline. They don't have time in a 3-minute segment to walk you through the FVR, the timeline, the court's actual language. That's why I tell people to go check the Blue Bill newsletter. 5 minutes a day, and it covers the details you didn't even know existed, the specific dates, the legal reasoning, the parts cable skips because they can't fit it in. If you take this seriously, and I know you do, you deserve the full picture. That's why I'm telling you now. Let me tell you something that makes this even more striking. This wasn't an isolated incident. This is the third time a federal appeals court has rejected this exact appointment method. In December of 2025, the Third Circuit ruled that Alina Habba, another former personal attorney for Donald Trump, was not lawfully serving as U.S. Attorney in New Jersey. Same mechanism, same workaround, same result. Then, just days before the Sarcone ruling, the Ninth Circuit ruled that Sigal Chadha in Nevada was also unlawfully serving. Same trick, same rejection. And there are more. Bill Saley in California, Lindsay Halagan in the Eastern District of Virginia, whose disqualification led to the dismissal of the cases against former FBI Director James Comey and the indictment against Letitia James herself. We are now looking at a pattern. This is not one mistake. This is a strategy. And it is failing in every courtroom where it is tested in front of judges appointed by presidents of both parties. And what happened after the first ruling against Sarcone back in January tells you a lot about the approach. When District Judge Lorna Schofield ruled him unlawfully serving, the panel of judges in the Northern District did what the law says they can do. They appointed a replacement, a man named Donald Cannella, a career prosecutor with over 50 years of experience, a former assistant U.S. attorney, a Republican. He was sworn in on February the 11th, 2026. And within 5 hours, Deputy Attorney General Todd Blanche posted on social media, "You are fired. Donald Cannella, judges don't pick U.S. attorneys. The president does." 5 hours. They didn't evaluate him. They didn't review his credentials. They fired a man with half a century of prosecutorial experience so they could keep a campaign lawyer in the chair. And I've got to tell you, when I was in the White House, we sometimes disagreed with the courts. Every president does. But we didn't fire the person the judges appointed on the same day on social media with a taunt. That's not how you treat the judiciary. That's not how you preserve the trust that makes the whole system work. Now, here's why this matters beyond the legal arguments. You're not going to find this kind of breakdown on any cable network. They don't have the time or the incentive to dig into what this actually means for the functioning of the Justice Department. The Blue Bill newsletter had the real details on this, the timeline, the specific FBR provisions, the consequences nobody's talking about on TV. The people who are reading it right now are not caught off guard by any of this. They already know the pattern across 5 districts. They already understand how the delegation argument was rejected. If you want to stay ahead of where this is going and not be the person at the kitchen table repeating what a cable host told you last night, that's where you go. So, let me tell you what I think happens next, because this fight is not over. The Justice Department has already said it will appeal directly to the Supreme Court. And this is a case the court may well take because you now have 3 circuits, the 2nd, the 3rd, and the 9th, all ruling against the same appointment method. And the administration is going to argue that the executive branch needs this flexibility. If the Supreme Court takes it, you're looking at a decision that could define how much power the president has to install prosecutors without Senate confirmation. And that's enormous because U.S. attorneys are not administrators. They are the people who decide who gets investigated, who gets charged, who faces the full weight of the federal government. If the court sides with the administration, you are essentially saying the president can put anyone he wants in that chair for as long as he wants with no Senate vote. And if the court sides with the lower courts, then this administration has to go back and do what every other administration has done. Nominate people, send them to the Senate, and make the case. Let me be clear. The president has not even submitted a nominee for the Northern District of New York. Not one name sent to the Senate. That tells you this was never about filling a vacancy. It was about keeping a specific person in a specific seat. And I think the thing that concerns me most is what this does to the prosecutors and the career officials inside these offices. I've talked to a lot of people in law enforcement and government over the years, and I can tell you when the leadership of your office is under a legal cloud, when the courts are saying your boss isn't lawfully serving, that creates chaos. Cases get delayed, morale suffers, defense attorneys challenge everything. The people doing the real work of fighting crime, going after drug trafficking, prosecuting fraud, those career prosecutors, they're the ones who pay the price. And that's not fair to them, and it's not fair to the communities they serve. A U.S. Attorney's office is not a political instrument. It is a public trust. And when you treat it like a chessboard for settling scores with political opponents, the whole institution is weakened. That concerns me deeply, and it should concern every American regardless of party. So let me close with this thought. If you do one thing after watching this one thing, go check the Blue Bill newsletter. I recommend it more than anything else I could point you to right now. 5 minutes, that's all it takes. And it's going to help you understand what this ruling actually means for your family, for the courts, for the next case that comes through that office. You deserve to have that clarity. Don't be the person who's always finding out last. Don't be the one at the dinner table just nodding along when somebody brings this up. This is your country. These are your institutions. And when the courts stand up and say, you cannot do this, that's not an attack on the presidency. That's the Constitution doing exactly what it was designed to do. We are a nation of laws, not of convenience, not of workarounds, laws. And as long as judges keep saying that out loud, I still have hope for this country. We've been through worse, and we've come through it. But we only come through it when citizens pay attention and when they demand that the people in power play by the same rules as everybody else. God bless you, and God bless the United States of America.